Hello, shall we begin?
Yes, madam.
Okay. So yesterday we had covered the first two aspects, that is on what are the things that cannot be patented and what are the things that can be patented. So before we begin, a quick revision with respect to yesterday's session. Can someone tell me what exactly is a patent? Under what circumstances do you use a patent? What can be patented and what cannot be patented? Without referring to the document. Hello. Without referring to the document, can you tell me what can be patented, what is patent, or whatever you understood from yesterday's session? Hello.
Hello, I'm audible.
Yeah, you're audible.
So a new kind of invention or a
Huh?
process which can add some value to the human being can be patented.
Okay. Human being or animal or something
And
that will help in mankind welfare. Okay.
exactly. Yes,
Yeah.
yes.
Just one thing you can answer in English or Hindi. Okay.
Okay,
That
madam.
is one more thing because those are the two languages that I follow. So that's why English or Hindi. The rest, if others don't understand, I will translate it for you. Okay.
Okay.
Moving further. Okay. Quick revision. We did copyright. We did trademark. We did patents. Okay.
Yes.
Patents are something that you will use to protect something that is an invention. That is what you will use to protect what you have developed in a lab or what is a man-made process, not something that is available naturally. Okay, let's simplify it. But yeah, if I discover a procedure to mine a diamond, or if I discover a procedure to, uh, you know, uh, to do fishing. Okay, fishes exist, oceans exist, that's absolutely fine. But
Yes.
I'm developing a new technique, a new type of net to catch the fishes without harming the other fishes or to clean the ocean. Then in that case, I will be eligible to register my technology or my methodology as a patent. Okay.
Okay. Okay, madam.
Yeah. So yesterday I had asked a question in the group. I had shared it with you all with respect to the diamond merchant, right? And first thing I told you is this is the first question that I will ask.
Yes, madam.
So can somebody tell me, okay, I'll just share the question once again. Can I register a patent for a lab grown diamonds? One. Second question was, a client has come to you and they want to launch their own range of lab grown diamonds. You are an IPR lawyer. As a lawyer, till now we have done patents, we have done copyrights, we have done trademarks. As a lawyer, what are the IPR registrations that you are going to suggest to them?
Uh, Madam, my understanding is the point
Huh.
number two, new form or non-known substance for which. So my understanding is though they have making a synthetic diamond or a lab grown diamond, but they are still competing to the original diamonds only. So mere discovery of a new form of non-substance which does not result in the enhancement of non-efficiency. So under this point, they cannot register for a diamond, but they can go for their own trademark under which they can sold diamonds. So I'll suggest them to go for a trademark, whatever they like, and register their trademark for the lab grown diamonds.
Okay. Any other answers?
Madam, can I?
Yeah, sure.
Madam, this artificial.
Yeah.
This artificial diamonds means lab grown diamonds, whatever it is. They're undergoing some different process. So patents generally covers under product patent as well as process patent. So this is a separate type of methodology to create artificial diamonds. Some certain process it has to be there, like high temperature, high pressure, more temperature, and some chemical technology. So this process it has to undergo. Then only it can form another diamond. This type of artificial diamonds. So as a process concern, it has to be patented. It can be patented, madam.
Okay. And you are an IPR lawyer. What suggestion are you going to give to your clients on what are the IPR they need to register?
Ma'am,
Hello.
Yes.
Yeah, you go ahead.
Just 1 minute. Mr. Mohan Rao, please continue.
Madam, I have no answer regarding this question. I request other participant to answer.
Okay. Rugved, would you like to answer this?
Apart from the trademarks as is already mentioned, I would also advise my client if he is making any kind of new design in that diamonds, then I would ask him to register that design, the patent of that particular design, because that particular design has been developed by my client. Even though so the what process he followed, even though the process might be the same, but that design is unique, and so he will get a chance to register his design of the diamond.
Okay, that's absolutely fine. That's a very good answer. So what basically happens is when you have a diamond, okay, a real diamond, suppose it cost around 2,50,000. That same diamond, if it's a lab grown one, will cost you, the diamond jewelry, not exactly the diamond jewelry, same jewelry. If you're making with a lab grown diamond, it will cost you around 80,000. So if you see that the whole concept is that even a common man can now have a diamond necklace or a diamond pendant, or see, one of the ways they have marketed this stone is by saying that if a man doesn't give his his girlfriend or wife a diamond while proposing, he doesn't truly love her. So that is the whole emotional concept that they have played around. That was the whole idea behind Bears yesterday, the brand that I told. You need to know the story, because that is the power of storytelling. How they sold a rock and said that if you cannot give it, that means you're not a good whatever spouse or whatever you are. Okay. The first thing is diamond, artificial diamond. The process to make, as Mr. Mohan said, yes, the process to make can be patented, because the machinery that you are going to use, and it is not only one company, there are going to be 10 companies which are going to grow the lab grown diamonds. Okay, if you have some time, some spare time, go and check out the designs on this website called as Jiva. That is a very big brand, quite registered. They fit these diamonds, lab grown diamonds, in sterling silver, which is a good quality silver. And even all those neck pieces and all are quite thin, but then it's a good thing for 2,000 or 3,000 rupees. If you're someone who wants to share it, who wants to buy some jewelry only because you want to wear it. Okay. But if I'm someone who's looking for an investment, I'll still invest only in gold. That's a different case. That's my personal choice. The reason I'm telling you to go and visit Jiva is you can see the designs on Jiva, see their finishing, see the diamond quality, and see a normal diamond or so-called diamond designs on any 10 rupee hair clip or a simple jewelry that you will find in any novelty store. Okay. The finishing of this Jiva diamond is as close as the real ones. Okay, so that is the differentiation. Second point about what are the IPRs that I would recommend. First of all, of course, I have to get their logo trademark. Okay, after the logo trademark, I will obviously the patent has to be registered, the process has to be registered, all those things will happen. Once the patent, the brand name, my mark, the design, if I am going to put my mark, for example, my name is Jiva, okay, Giva, and then I write G in a particular format, and I want that all my jewelry, whichever I'm launching in that line, should have this logo. I can register that logo also. After that, once I begin with my marketing, as you said, copyright registration of designs you want, you can do. It is optional. But then wherever you are launching it, you need to keep proof that on this particular day, I had launched this design in this particular store. Then coming down, you will also have to talk to them about copyright of your product during advertising. Okay, IPR also plays a huge role when you're advertising your product. So when you are creating an advertisement, who will own the IPR of the advertisement, whether it is your client or whether it is an agency? All those things you have to instruct your client, even though these steps happen in step by step, but making your client aware about the intellectual property rights that are involved in launching a new project is your duty. Okay. Then yesterday we spoke about the different products or different procedures which cannot be patented. Then we spoke about what can be patented. One of the novel features was that the product has to be unique, not the product. The procedure has to be something unique. It has to be inventive. It should be non-obvious. It should not be something that I have already copied. Okay. Now, this term of non-obviousness doesn't exist in the case of diamonds because original diamonds are mined from the diamond mine. And these lab-grown diamonds have got to do nothing with diamond mines. Okay. The raw materials used is different. The diamonds or emeralds or whatever you do, this whole mining process is done of something. That whole procedure of formation of that stone is done by the nature. Only digging it from the mines and bringing it to get it polished is what a human being is doing. But in a lab grown diamond, right from getting your basic materials to creating an artificial diamond is done by people, and therefore you can always register the process. Okay, so your process is natural process versus man-made process. So therefore, the procedure create this artificial diamond is non-obvious. It's an inventive step. There is industrial application. There is utility in this particular case. I've just taken this an example. It's not exactly the case study, but then as we are only talking about diamonds, we'll just carry on with the same. This invention is something that is used in the industry. Now, this benefits a lot of jewelers because as diamond is affordable, a lot of people will buy jewelry. Okay. Gold ka sale, the sale of gold increases automatically because people will want, okay, this is an expensive necklace. I want this, blah, blah, blah. People will buy. Unka to sale ho raha hai. So a particular industry is progressing. And trust me, the gold industry and the jewelry industry, it contributes a lot to the economy. So technically, yes, it has a utility, it has an industrial applicability. Can you scroll down?
Yes, madam.
Then we spoke about what are the patent application process. So with respect to the patent application process, it's a simple process. Just like your trademark application, you will have your patent application. You have to go and file for your patent before the office of the controller. Okay, they will be there in every state. Only differences in case of trademarks, it can be done by an individual. In case of patents, you need to go and get it done through the patent agent. Okay, a patent agent is a registered lawyer who has given the patent exam, and he or she has a background in science, engineering, or medicine. Okay, so your patent agent will go, they will file an application, that is your ordinary application, convention application. If you want to launch internationally, then international applications, or your national face applications. So these are the forms that are required: Form 1, Form 2, Form 3, and Form 5, because you have to also declare your inventorship. Now, along with your patent, okay, you have to, one of the other documents that I am aware about is you have to show your research. For example, if I am designing whatever you say. Okay, let's talk about diamonds itself. So I'm designing this machine which will compress carbon. What happened in over a span of 1,000 years, I can do it in a span of 2 years. What was my inspiration? What was my calculation? What is the temperature that I have used? What are the artificial methods that I have introduced? What is the artificial scenario or artificial environment in which I have placed the particular diamond? All these details will be mentioned in the specification, which will go along with this application. Please scroll down. This application is published again under official patent journal. Now, these patent journals are generally available in all the major libraries, and the people who are in the field of research and development, they regularly go through the same. Okay. So if somebody is developing something similar to them, is published in the journal, they know, and then they can raise an objection. Request for examination. Now, once your patent is pending, you have to request for examination. That is, the inspectors will come, they will check your machines, they will see that does it have any side effects? Is it something that can be used for a negative purpose? Is it something that can be used, for the benefit of mankind? All these details they will come and check. First thing is it novel? Is it inventive? Or is it just copying a traditional method that already existed? After the examination, then they will give you an examination report. Under this examination report, you will be provided all the details on what is their finding of the same. So if they feel that this particular technique, for example, if it's about the lab grown diamond, okay, they are saying that you are using this technology, it's absolutely good. But then when you're using this technology, the chances are that, you know, when you're using this technology, the chances are that you will not, your product has been giving a lot of environmental issues. For example, when I'm compressing coal and making this artificial diamond, there is a lot of byproduct which emits a lot of CO2 or carbon monoxide or some dangerous gas. Okay, that may be a problem in my invention. That is something that either I can rectify or something that I can give an explanation that, okay, even though suppose carbon dioxide at this percentage is being emitted, but then I also have a technique under which I can ensure that, there is a check, or I can create something else from this particular carbon dioxide. So this is just an example I gave. I know it makes no sense, but this was just to simply explain. Okay, so whatever is the response, you have to give your response within 90 days. That is 3 months or 6 months. Okay. Then once your examination report comes, then you have to file for your, then your patent is granted. Okay. The government, the patent office will grant you your patent. Just give me 1 minute. So once your patent is granted, then it belongs absolutely to you, if all the requirements are fulfilled. If your patent office is not satisfied with the answer that you gave for their objection, then again you have to appeal. All this appeal and grant and all is taken care by the patent agent. Okay. Now, after you have been granted a patent, there are chances that somebody may have some objection with respect to, your patent agents and with respect to your patented product, that it is similar to theirs or whatever it is. Then they have to take an objection within 1 year. Okay, they cannot wait forever. Whatever objection is, that has to be taken in the duration of 1 year. Okay, so this is what we covered till yesterday. Any objection till now? Sorry, any queries till now?
I have some queries. About this examination, a request examination Form 18 must be filed within 48 months. Once we have filed an application for grant of patent, why again we need to file an application to examination in 48 months, and why this so much 48 months? Why they required, and 4 years, they required 4 years to file a application for examination?
That has to be a request for examination. See, technology is something that keeps on developing. I can apply for a patent today. Okay, it just says maximum time that is given for request for an examination. For example, when I just told you that there may be chances that your machinery may have certain defaults. Any machinery that is developed in the first go will not be perfect. It will have some of the other flaws. You should always request for examination only when your technology is completely ready. And technology doesn't get ready overnight.
Okay.
Okay, so that within 48 months is the duration that is given. That's a maximum upper limit that has been given for you to work on your technology. I'm sure nobody wants a faulty CT machine to be patented, or nobody wants a faulty stethoscope. Those things can't have patent, but nobody wants a faulty product in the market, which is causing a huge damage to an individual, or which is causing a huge damage to anybody, huge damage to a mankind, animal farming, etc. So in order to work on your product, you have been given this opportunity. Okay, so what happens is, now I am Sipla and you are, just give me another medical company name.
No, it is
Dr. Reddy's. Sorry?
Novartis or anything, Dr. Reddy. Okay.
Yeah.
Ciplas and life.
Yeah. So, yeah, I am Cipla, you are ready. Okay. I am developing a medicine for COVID.
Okay.
Not COVID. Let's take something simple for a common cold.
Okay.
You are also developing a medicine for common cold. Okay. Because internationally there is a news that drug A, B, C, D is something that can cure your common cold.
Okay.
We both come to know about it. You are also developing. I'm also developing. Basic drug that we both are using remains the same, because tomorrow Indian government decides that we are going to give benefits to tax benefits to any company which will develop a medicine using so and so drugs. We'll reduce your import duty, export mein we'll help you out, and also we both decide ki chalo hum dono medicine banate hain. Now making a medicine for common cold is not something that you can do overnight. It will take some time. In
Okay.
that case, both of us will approach to, when my medicine is almost 80 to 90 or 95% ready and my clinical trials are going on, I will approach for patent. Okay. Clinical trial results, it takes around 3 to 6 months to come. There
Yes.
are chances that my medicine, Cipla, okay, I'm Cipla, my medicine may give some side effect for people who are diabetic. There are chances, that your medicine, your combination of drugs can give you some side effect, like a back pain or something. So the chances of error are very less, but they are there. I have worked, around 4 years for this invention. And of course, I want to be the market leader, no? The prime basic idea is both of us need to make money and both of us want to be the market leaders. So that is the whole reason why I'm going to protect my invention. I'm going to protect my formula. In that race of both of us wanting to be first, okay, I want to launch a cold medicine which is going to ensure ki you're someone who can't get up from your bed, but using my medicine without any side effect, in 12 hours you'll be able to stand on your feet. That is the claim that I am making. Okay, even though Advertising Standard Council of India will not allow you to give an advertisement like this, but this is what I exactly want. So therefore, I want my patent also to be registered first. So what I'll do, I'll apply for patent. My clinical trials are still going on. Okay. When I have applied, my report will be published. Your report will also be published, even though, thoda 19-20 ka farak hai between your formula and my formula. Now, as I said, if there is any problem in the clinical trials, I get to rework on my formula. I can reapply. I can again ask for re-examination. And that's why the whole duration of 48 months is given.
Okay, madam. One more thing, madam.
Yeah.
I filed an application with all the parameters required, all the description, all the process flow, everything I have submitted to them. So they came for the examination. I have point that I have set parameters according to their rules and regulation. So while examining my application or my process or my invention, will they go out of their jurisdiction? As you say, if there are some carbon emissions norms, will they check all these also? Because invention is something different thing, and the emissions and all the other norms are some other things. They go.
Your norms are other things, but then it will come under something that it doesn't have an industrial application.
Okay.
Okay, if it is something harmful, why will I promote it? Why will I permit it to be launched in the market?
But my point is that it is something different. It is something invention that I'm going to be going to protect. Though
yeah, but how are you going to complete all the parameters, when one of the parameters, the basic parameter is that your technique has to be unique and it has to be beneficial to the mankind. Carbon emission is not something that is beneficial to the mankind.
Okay.
You understand?
Got it.
Quality checks also be carried out now, madam.
Sorry?
This product quality checks will be carried out. Then only it has to be processed for patent, right?
Yeah.
This quality should
They will
quality
not
assurance
do,
and everything.
yeah. They will not do quality check according to the ISO standard or according to, your environment protection laws. But they will do a basic superficial check. And that is one of the reasons why a person writing the specification needs to have a scientific background. Okay. So that is the whole reason. Otherwise, there was no such requirement until a few years ago. At least 2007-8, there was no such requirement. So
Okay.
we'll just move on to the case laws. Case laws, I'll just generally do it now, and then we'll have one session only for case laws. That is on Nova Rights versus Union of India, in which Nova Rights application of patent for the cancer drug Glyvec. Okay, it was with respect to that. The Supreme Court of India denied the patent, citing the drug did not meet the enhanced efficacy requirement under Section 3D of the Patents Act. This case emphasized the importance of preventing evergreen patents. That is, they wanted an evergreen patent for their invention of Glyvec, which is an anti-cancer drug. Then we have Roche versus Cipla. In this case, a patent infringement suit was filed by Roche against Cipla for manufacturing a generic version of Roche's patented lung cancer drug, erlotinib. The Delhi High Court ruled in favor of Cipla, highlighting issues related to patent validity and public interest. So in this case, what had happened is Cipla had infringed the patent filed by Roche. They just launched a generic version of this particular drug. Monsanto Technology LLC versus Nuzivedu Seeds Limited. Monsanto sued for patent infringement related to genetically modified cotton seeds. The Delhi High Court ruled that Monsanto's patent claims were invalid under Section 3J of Patents Act, which excludes the plants and animals from patentability. This case had the significant implications for biotech patents in India. Okay, so that is why we have your Plants and
Animals.
Plant Variety Act to protect all the development with respect to development in the plant and animal industry. When I talk about animal industry, it is the livestock industry. Merck Sharp and Dome Corporation versus Glenmark Pharmaceutical. Merck sued Glenmark for patent infringement concerning diabetes drug sitagliptin. The Delhi High Court ruled in favor of Merck. They granted them an injunction and thereby reinforcing protection of pharmaceutical patents in India. So you have to protect your patent globally. You have to either register it globally or you can protect it with whatever laws in India. Like, just because a drug has been launched abroad doesn't give you the right that you can copy their formula and launch it as it is in India. Okay, now this process is rigorous, but the reason why it is rigorous is so that only genuine inventions are patented. Okay, so patent invention generally occurs when a patent invention is made, used, or it is offered for sale, sold, or imported in India without the patent holder's permission. Now, Patent Act 1970 is an act which provides the framework for identifying the acts which amount to infringement and the outlines. What are the outlines under which infringement happens? Okay. So now we'll move on to what exactly constitutes to a patent infringement. Now, making a patented product or using the patented process. I am we just did a case law of Glenmark, wherein they just blatantly copied the formula of a drug of an international company and sold it in India. Okay, so they are technically using the patented product and putting their label, offering sale or selling patented product. Okay, even if today Glenmark is not manufacturing that copied drug, but there is some XY company which is selling this particular patented drug. They know that this is wrong. Then that also amounts to patent infringement. Okay, probably the patent infringement happened outside India for both the companies. You know, but still you are selling it in India. Importing the patented product, importing a patented product without the permission of the patent holder. For example, importing laptops. Okay, I cannot import a laptop and sell it as my own without the permission of the patent holder. Okay, I can enter into a deal with Lenovo and say that okay, we will be official sellers for you. These are the taxes applicable for you, taxes applicable for me. And then let's get into a formal deal. But then I cannot apply, I cannot sell a patented product. Okay, a Lenovo laptop is something that is patented. I cannot sell it directly as a seller or as my own without taking proper permission from them. Then comes in remedies for patent infringement. One is injunction. You have temporary injunction wherein the court will restrain an owner from continuing certain activities, and then you will have your permanent injunction, which is forever. There will be a ban that you cannot sell Lenovo laptops forever without taking a permission. Or I can say, you cannot sell Lenovo laptops without entering into a contract. Maybe we had a contract and the terms were not clear. So these are the remedies. Then, of course, you have your damages accounts that have to be calculated. You have your delivery up or destruction of infringed goods. Now, in some cases, there is also a possibility that the government can ask, destroy all the Lenovo laptops that you have brought into the country without proper permission. There is a chance to destroy these goods. Okay, cost. The court can also ask you as an infringer to pay the cost, whatever is the fine, whatever is the damages that may have occurred. Now, what are the defenses against patent infringement claim? What are the defense that you are going to claim? One is invalidity of patent. The alleged infringer may claim that the patent is invalid due to lack of novelty, inventive step, or industrial application. There are chances that you and I both are competing to develop this particular drug for body pain. Okay, we both are pharmaceutical companies. I have filed for a patent, and my patent has been what do you say? It's under the process. It's been published, and you are also working on something that is similar. You can say that this particular medicine should not be granted patent because they are just trying to imitate. They are just trying to claim a patent. There is nothing novel. There is nothing inventive. There is no industrial application because they are just remarketing a procedure which is already known in the pharmaceutical industry. Non-infringement. The defendant can also argue that they don't intend to infringe the patent claims. Then you have experimental use. Okay, you can say that you are developing this particular product only for the purpose of experiment. Then you have Bolar Exemption. Activities related to development and submission of information required under any law regarding manufacture or use or sale of drug. Okay, so when you are developing a drug, you can say that whatever are my combinations, I need to protect it, and this is how it is going to benefit. Okay, even though we are using more the same combination, me and the front person, but I am trying to use a different technique due to which my medicine is going to cost 25 rupees. What Glenmark is selling is going to cost 250 rupees. Okay, so this is again, even though we are using the same formula, this is how I can argue for my patent. Government use. If something is to be done for the government use, you cannot like use of patented invention by the government or by third parties authorized for the government for its purpose. For example, your defense tools or your medical equipments cannot be patented. Okay, so it has to be used by the government or someone who has been authorized by the government. So that is again one more defense. So you cannot raise an objection in such a case. Okay. So relevant laws on patent infringement in India. One is TVS Motor Company Limited versus Bajaj Auto Limited. This case involved a dispute over patent infringement related to DTSI technology, which was used in motorcycles. I remember seeing the ads which spoke about DTSI technology. The Supreme Court allowed TVS to manufacture its product, provided it a deposited bank guarantee, and emphasized a balanced approach to interim relief. So even if you are both of these are bike companies, okay? So when two bike companies are using the same basic technology, that is the DTSI technology in this particular case, the Supreme Court said that it allowed TVS to use the same technology as Bajaj, because again, it's again for the welfare of the people. If a bike is getting cheaper, and Supreme Court didn't say that, you know, you are infringing Bajaj's right or Bajaj is infringing your right. It gave a very neutral and a diplomatic approach. Hoffman La Roche versus Cipla. Roche sued Cipla for infringing its patent. This is again the same same case law wherein a relief was granted to Roche considering the public interest in accessing affordable medicine. Merck Sharp and Dome for Glenmark Pharmaceuticals. At Delhi High Court, they ruled in favor of Merck because Glenmark had infringed Merck's patent on diabetes drug, and they had granted a permanent injunction. That is, permanently Glenmark was banned from promoting that product. Okay. So the next case, again, it's with respect to cotton seeds, which we did earlier. So in case of, you know, patent infringement in India, it involves authorized, unauthorized use to manufacture, sale, import, remedies, injunctions, damages, delivery, or destruction of infringing goods and costs. Then the defenses can include invalidity of patent, non-infringement for experimental use and government use. Okay. So this defense that I'm going to talk about once again is the defense that you will use in case if there is an objection or for your patent in a court case that has been filed against you, which includes the first 5 are the same objections as a defendant that you can use if there is an objection raised before the office of the controller, that is during the filing of your patent. And this is what you can use after the filing of your patent. First 5 are same, so I'm not repeating. You can also argue that your product was in prior use, it was already in the market. You can say that the patentee's conduct, such as anti-competitive practice, can be a defense to infringement. For example, tomorrow, if Cipla decides to launch a drug, okay, in India for fever, Cipla cannot enter into an agreement with all the medical stores, or Cipla cannot enter into an agreement with all the doctors in India saying that, you know, you cannot enter into a particular, you cannot sell any drugs or you cannot recommend any drugs made by my competitor. And tomorrow I decide to launch a same drug at a cheaper rate. Okay. So this particular act by the front company will cause a damage. Okay. That is a point that goes into my benefit for protecting my rights. Then comes exhaustion doctrine. That is, once your patent has been sold out in open market, or if my duration of patent is over and I have not renewed it, then I can clearly use it. Okay. So any queries till now?
No, madam.
No, madam. Basically, this is a very vast subject. We have to study a lot about it.
No, it looks vast, it looks overwhelming. That's why I said, that's why I've been revising copyright and trademark. If you are thorough with copyright and trademark, all three are similar. It's not, it looks scary. Patent looks very dry. Trust me, even I hated patent when I was in law school.
Okay.
It makes you sleep. That's a fact. But I can't help it. I'm trying to make it as interesting. So it's not a general problem. It's not your only problem. It's a very general, too dry subject. We can't help it.
Yes, ma'am.
Abhi hai to hai. Okay. So then these are a few case laws, that is Innova Tech versus Future Tech. In this case, the Supreme Court held that the Innova Tech's use of a Future Tech's patent technology for research and development purposes fell under experimental use exemption. The court reaffirmed that activities aimed at improving or testing a patented invention for experimental purposes are not considered as an invention. For example, the front person is has already got a product in the market. I have also planned to launch something very similar, but I am still in an experimental phase. Okay. So that does not mean I am infringing somebody's patent. Okay. Then is Government of India versus Agritech. The Supreme Court ruled that use of Agritech's patented seeds by a government agricultural research institute did not consider to infringement due to the government use exemption. The court highlighted that the importance of government use provisions in promoting public interest and research. I can give you, simplify this for you. For example, we spoke about seed modification. Okay. Now, seed modification is something that has been happening since the Green Revolution. There is a particular type of corn seed which has been developed by XYZ company. Okay. Now, this XYZ company decides to launch it in the market. Okay. They will launch it saying that, now this XYZ seed has been used by the government in one of the experiments that it is conducting. Probably they are using corn seeds to make better corn starch. Now, this company, which has already got a patent for the process to make the extract corn starch easily from their corn, cannot challenge the government saying, how are you using my technique? So the government can say, see, I'm trying to do something at a much cheaper rate for the common welfare, because probably when you extract or provide corn starch at a cheaper rate, it helps in preparing of food at a lower cost or something like that. Okay, this is all fictional, nothing is true, nothing is real. I just made up a story so that you could understand the concept. Okay, BioHealth versus GreenMed. The court found that BioHealth's manufacture and export of generic version of GreenMed's patented drug for regulatory submission in another country was covered under Bolar Exemption. This decision reinforced the scope of Bolar exemption in facilitating generic drug development and regulatory compliance. That is, just because something is regulatory, something you're working on a generic drug, that doesn't give you a restriction, a right to restrain. Okay. For example, paracetamol is a basic drug. It's a generic drug. Company A can also develop a drug around it. Company B can also develop a drug around it. Okay. So you cannot claim, what do you say? You cannot claim an infringement for the same. Okay. So any queries, anything you want to ask or say with respect to this topic?
Madam, this Bolar exemption, I think this term has something meaning, no? Bolar.
Yeah. So Bolar exemption, it means activities which are conducted for development and submission of information required under any law regulating the manufacture, use or sale of drugs that are exempted from infringement under section 107A. So for example, that's what I said. For example, you and I both are creating medicine for cold or for fever. Paracetamol is a very generic drug which will be used.
Yes,
Okay,
ma'am.
that's a basic generic drug. Now, just because you are developing a medicine using paracetamol, I cannot challenge you. Using that
Yes.
basic generic drug is the right of every pharmaceutical company. There is no patent which can be granted for the same. So this Bolar exemption is mainly with respect to the pharmaceutical industry.
Okay.
Okay. Then we will move on to international patent treaties, which India has signed. We'll just quickly browse through the same. Paris Convention for Protection of Industrial Property. India is a signatory in the same, and in which this treaty it facilitates priority rights for patent applications filed in member countries. Then we have the Patent Cooperation Treaty, in which again India is a signatory. India is a contracting state in which it allows inventors to seek patent protection in multiple countries through a single international application. When we earlier did today's session, we saw that there are multiple applications, whether you want to sign under PCT, whether you want protection only in India. So according to that. Then you have agreement on trade-related aspects of international IPR, that is TRIPS agreement. As a member of the World Trade Organization, India complies with TRIPS, which sets minimum standards for various forms of IPR, including patents. So this TRIPS agreement is something that is important. We'll do it later in the class, which sets the entire standard on how the IPR related laws should be formed in all the countries. Okay, a lot of countries are signatories to this particular act. Okay, then we have the integration. So your Patents Act was basically amended several times so that you can be on par with these international treaties that you sign. Then you had the patents rule, which were introduced in 2003. They provided a detailed procedure for patent applications, including those under Patent Cooperation Treaty. Applications under Patent Cooperation Treaties are international patents. Okay. Then Patent Amendment Act 2005, it significantly updated the Patents Act to comply with the TRIPS requirement, and it introduced product patents in all field of technology. That is, till now, we just had the inventive procedure, and now we have this concept called as product patent, wherein the product itself. Okay, we spoke about the diamond. So someone, I think Mr. Mohan spoke that, the diamond in itself can be patented, the lab grown diamond. So that is what is product patent. Okay. So any queries till now with respect to the Patent Act?
Madam, I have a practical question.
Huh?
From the filing to the actual receipt of patent, there is a time gap. So in that time gap, how practically
That is why when you file an application, it is published in the official journal. Okay. Once it is
Okay.
published in an official journal, it means this idea is something that has been registered or is in the process of approval or whatever it is. Nobody can copy this idea or this invention.
though
So
I have received a patent?
you don't receive a patent per se, but then everybody knows ki, haan, you are doing a particular invention this way. So nobody will try to copy you. Or even if they are trying to develop something similar, they will make the changes.
Okay.
100% information about you won't be provided. 80-90% will be provided. There is
Okay.
another chance also. Your competitor may just create the product and launch in the market.
True. True. Exactly.
Okay. But then his technology won't be patented. His technology won't be exclusive. Patent is an option. So people who want to go for funding, people who want exclusivity in the market will opt for registering of a patent. If
Okay.
I'm in the medical industry, then of course I need a patent before I, sell my medicines. So these are the small things that matter. IPR is a choice, but nowadays it's no longer a choice. Nowadays everybody goes ahead and does it because all want exclusivity, all want industrial leader, and more
Means you should be graduated in science, right?
Yeah, a
Okay,
science
and
that is either BL engineering or MSc or something similar.
okay. And where we need to approach? Means is there any URL or something like that?
I'll just send you the link in the group
Great,
where you
great.
can approve.
Thanks, man. Thanks.
Okay. Yeah.
Thank you, madam. Thank you.
Yeah. Thank you so much and have a great day.
Thank you, ma'am. Thank you, everyone. Bye.
Bye.